So I was asked to make a presentation on the regulation of nanomaterials, so I kept the title just as I was asked. So first of all, let me tell you who I am or where I come from. I work for an organization called ClientEarth. It's an organization of activist lawyers mainly. We have also scientists working with us, and we try to use the law in order to solve environmental challenges like the many that we have spoken about so far, and try to mediate with the science, which is not always very easy. We have several programs. There's about 30 of us working with ClientEarth and 3 offices in London, Brussels, and Warsaw. I work for the Health and Environment program, and I work specifically on toxics, mainly on REACH. So, nanomaterials and the law. Let's see. I took these photos on products containing nanomaterials, and I didn't take them as a guess. I just went on one of the existing databases, very poor in terms of data, existing databases. So I took photos of, these are companies that voluntarily submitted that their products contain nanomaterials. So sunscreens, a lot of sports equipment, paints, and for those of you that have one, iPhones as well. So what are the problems with nanomaterials before going into the regulation? There's quite a bit of ignorance about properties and, well, a bit about everything. I mean, if we ask an average citizen what they know about nanomaterials, probably they don't know that much. We can say that it's most likely there's widespread presence of them, and there's doubts about the benefits of them, or at least of some of them. There's a lack of regulation, which is arguable. Some say there is, some say there isn't. As I said, problems on hazards, what are the hazards, what are the risks? And lacks of ways on how to measure them. So these famous test methods that we were talking before, are they fit to explore the hazards of nanomaterials? We don't know that. Probably not. So let's see what is the legislation applicable to nanomaterials, and I go for a quick historical excursus. So another strategy, after what Lisette explained, the strategy on EDCs, which is from 1999, and while for nanotechnology is from 2004, and it seemed that the Commission wanted to have a very proactive approach, saying that nanotechnology must be developed in a safe and responsible manner. Maximum use should be made of existing regulations, so they believe that existing regulation of the time covered already nanomaterials. However, the particular nature of nanotechnologies requires their re-examination and possible revision. Let's see if that happened, because in the meanwhile there was the REACH regulation, the new pesticide regulation, etc., etc. So in 2008, after REACH and pesticides, the Commission says in its communication on the regulatory aspects of nanomaterials that REACH doesn't refer specifically to nanomaterials, but they are covered by the definition of substance. So they have 2 key conclusions: that current legislation covers in principle the potential health, safety, and environmental risk of nanomaterials, and implementation must be enhanced with current legislation, so REACH. However, at the same time, ECA, with some projects for developing guidance, and this is a particular guidance on substance identification, ECA says that the current development in nanotechnology and insights in related hazards effects may cause the need for additional information on size of the substance in the future. But the current state of development is not mature enough to include guidance on the identification of substances in the nanoform in this guidance documents. I don't know, the current development state of development is not mature enough what exactly means, but probably the scientists that will speak after me will probably assess if their knowledge was sufficient to identify nanomaterials. As a response to this communication, the European Parliament, well, just going through quickly, basically criticized and didn't agree with the Commission because both of of an opinion of the EU scientific committees that believed that there was not enough of knowledge about them, and there was not enough ways in legislation to address the problems of nanomaterials. There's no clear information about the actual uses, etc. So through this body of knowledge that we had, and that the European Commission particularly believed that nanomaterial were covered, what do we have now? And Professor Tarazona has mentioned that nanomaterials are already covered. So what does REACH give us? Here's all the evidence on REACH registration of nanomaterials. Only one substance so far has been registered separately as a nanomaterial. There are other 3 substances, and these are multi-walled carbon nanotubes, which include a number of nanomaterials in any case. And other 3 dossiers indicate that they are submitting at the same time data on the substance in the nano form and on what we can say the bulk form, the non-nano form. So, but after that, anyway, some regulation of nanomaterials was developed after REACH. The first is the regulation on cosmetics that foresees the labeling of cosmetics containing nanomaterials, but that applies only from July 2013, if I'm not mistaken. Then regulation on the food information to consumers that provides, again, for labeling of food containing nanomaterials from December 2014. Then there was a non-regulatory measure, but the recommendation on the definition of nanomaterials. So finally, member states, the EU, they finally decided what is the definition of nanomaterials. Probably a bit poor as a definition, but as I said, other may be able better to assess why it's not that fit for the purpose. And very recently, probably the best step in the direction of the regulation of nanomaterials is the new biocides regulation that foresees that there has to be a separate assessment for nanomaterials from the correspondent bulk substance. There was an attempt in the proposal for a novel food regulation to include a moratorium of nanomaterial in novel foods, which are basically defined as foods that came into the market for the first time after 1997, so new food, let's say, and a positive list of nanomaterials that can be added to them. And then quite interesting proposal of a register of nanomaterials in France, which seeks at having a good picture of what nanomaterials on the market, what kind of in what kind of products, and has a very low threshold, like 100 gram for the notification. And finally, ECHA issued just a couple of weeks ago annexes to their guidance on information requirement to develop their chemical safety assessment, which gives guidance on how nanomaterials should be registered. This is not a law. Obviously, REACH, the obligation of REACH are the same since the beginning of the registration, which was in 2008. So what do environmental and health organizations suggest for nanomaterials? Since the process of adapting other legislation has not been working and it's not that quick. Even hazard communication, although in some cases it has been added, let's say for cosmetics, it will be 2013, but how much of sunscreen will you have used containing nanomaterials and without knowing their effects until that provision will be implemented, and for the same for food. So we suggested to started for now to member states in a recent workshop in the Hague a separate regulation that would define nanomaterials, consider nanomaterials as new substances, because as it was explained earlier, REACH has deadlines, and for substances that are so-called phase-in substances that have been on the market for quite a long time. You can register them at different phases, like first December 2010, then May 2013, and then May 2018. But in this case, nanomaterials are considered as if they were old substances, but in reality, they never came on the market before, just recently. Establish a register of nanomaterials, so similar to the French proposal, but Europe-wide, just to have a clear picture of what we have all over in Europe. Having low tonnage thresholds in REACH, because REACH applies only to substances, registered substances only after 1 ton, and the assessment, the real assessment, the chemical safety assessment, has to be done only at higher tonnages. And provide for a thorough evaluation of all nanomaterials that are registered, because the main problem is not that we believe that nanomaterials are bad, you know, the basic question, as a speaker said before, it's all about, is it good or is it bad? But what we need to know is what we need is to fill the knowledge gap, and we can do this only by requiring registration and by evaluating the data that is given by the registrant, because the registration of the data is basically what the registrants say, but it needs to be validated. And finally, but probably this is a precondition, have appropriate test methods for nanomaterials before any evaluation and any tests on animals are done. Otherwise, they would probably be completely useless. So, first set of conclusions on the lessons from the Nano Challenge. So in the 2004 strategy, the Commission said that a proactive approach should be taken. So by 2012, we don't have much of that proactive approach. There hasn't been no reaction to early warnings of nanomaterials. It's not my job to describe the studies that have been issued so far, but there's quite a bit of evidence from a few studies. Well, one is that is usually quoted is how carbon nanotube may behave as asbestos and cause mesothelioma. That I would consider that an early warning to be validated, but no action has been taken in that direction. So, precautionary principle for nanomaterials was not really taken into account. And the same, a regulation for nanomaterial is unlikely, if it will ever come, it's unlikely to come into force before a number of years. So again, how much of these substances we will have in the environment and in our bodies before we find out that they may cause some hazard. And finally, if these early warnings will be confirmed, who will pay for it? Finally, I have just some questions for you, because we've been discussing about early warnings and new technologies and GM and all these issues. We had GMOs, we have nanotechnologies, but we see that public authorities are not very quick, not very responsive, because decision-making process inevitably take time. But should we have models of responding to new technologies, and how should those be developed? Like, the law seems to, doesn't prevent problems, but try to solve problems, and it comes late when damages have already occurred. As we've seen for the cases of pesticides, some of them have been banned a long time ago, but we still have them in our water, in our bodies, etc., etc. So how will we deal with the next innovation, and how should we deal with the next innovation? And hope I was quick enough. Thank you.